Hello and good evening. My name is Jim Kovaleski. I'm one of the attorneys at O'Donnell, Weiss and Matei, and I'm joined this evening by Thomas McCabe, otherwise known as Tip McCabe.
Hi, Jim. How are you?
I'm doing well. Yourself?
Excellent, thank you.
Great. And Tip and I are going to talk a little bit about residential leases, commercial leases, and the differences between the two. So, Tip, I'll start you off real easy. With residential leases, is there something that we have to pay attention to, so a specific act or rule or anything like that?
Yes, Jim. There's the Landlord-Tenant Act, which is the rule and the law of the land here in the Commonwealth of Pennsylvania that protects landlords and tenants in residential leases. It describes the rights and responsibilities of both the landlords and the tenants and ensures a kind of basic minimum of protection for both sets of parties when they're entering into this contractual relationship.
Thank you. So when we talk about leases, do they need to be in writing, or can you and I just agree to you're going to rent the room in my house that I have for rent today?
Well, it depends, Jim. If the leases are under, or the lease term, I should say, is under 3 years, so 3 years or less, then you don't have to have a written lease. You can have a verbal, oral lease, and that's perfectly permissible under the Landlord-Tenant Act. It's certainly advisable, though, that you have a lease in writing because certainly opinions between landlords and tenants, especially if there's a breakdown in the relationship, can change. And if you have the agreement out in writing, it's much easier for the parties to know where they stand, and certainly if it gets to the point of litigation, for a court to decide who would prevail.
And that makes sense. I mean, we advise all of our clients, this is essentially a business relationship. So if you're going to have a business relationship with someone, define those terms, have them written down so that if there's ever an issue, you can go to that and see exactly how you decide to handle that situation without there being any animosity or any disagreement as to what those terms are. So that makes a lot of sense. Some of the key terms that we would look for in a lease, whether it's residential or commercial, is security deposit. Security deposit is the amount of money that the landlord holds. It's not rent, it's separate and apart from rent, but it's money that the landlord holds, that's the tenant's money, until the end of the lease term. That money can be used for things like repairing damages. Anything else that you think of, Tip, that the security deposit would come into play for?
Well, it could come into play for rent arrears or rent that's due. So if a tenant leaves the property or vacates the property either through eviction or otherwise, and there's rent that they owed the landlord, and there's a security deposit there, that security deposit can go towards that rent that is owed.
And then what happens to that security deposit?
Well, it depends, again, when, again, this is dealing with residential leases for those of you that are tuning in. When a tenant leaves the property, whether through voluntary action or because a court evicted them, the landlord has certain responsibilities under the Landlord-Tenant Act that they have to perform. And that is within 30 days of the tenant leaving the property, the landlord has to provide an itemized list of any damages, if there are any, and return any security deposit less those damages or outstanding rent. And it's very important that the landlord does that. It's highly recommended that the landlord does this in writing and certified mail to the tenant's new forwarding address. The reason is, if the landlord fails to do that within the 30-day period, the landlord can be liable for double the escrow amount.
So, very important for landlords, but also very important for tenants to be aware that if you're a residential tenant, you have 30 days, you should be getting a notice as to either here's your full security deposit back or something less than full, and here's where the money was spent on. No, it makes a lot of sense, and it helps protect the tenants, and it gives them a time frame so that they know within 30 days they're going to get it. But very important for those landlords to do it so they don't get held and all of a sudden have to pay more than what the actual security deposit was.
And it's very important for tenants, Jim, when they are leaving the premises, again, whether voluntarily or by court order for an eviction, that they provide the landlord with their forwarding address. Because some of these protections under the Landlord-Tenant Act, such as getting your security deposit back or getting double if the landlord doesn't do it, are waived, meaning they don't apply if the tenant fails to provide a forwarding address. Now, in our digital age, a lot of tenants will say, well, I emailed or texted my address. That may or may not hold up in court. It is much more strongly recommended that in writing, that you provide something kind of old school, snail mail, in writing and retain a copy of it to provide the landlord with your forwarding address.
No, good advice. Very good advice. Let's go back to what other lease terms that we want to see in any written lease. And again, we always recommend, whether it's residential or commercial, that it be written. And they include things like, what is the term? How long are you renting this place for? What happens at the end of that term? Sometimes I see renewals, so the tenant might have the right to renew the lease for another year if that was the initial term, but they have to do certain things, such as giving written notice that they want to renew. Again, going back to that concept of not to be overly formal, but it's a good idea to give written notices in any of these situations. Tip, what other things do you think of? What do you think of as far as terms that should be in a lease?
Well, it kind of goes without saying that the rent amount, meaning what you're paying every month and or whatever frequency it might be, it needs to be in there. When the rent is due, how much, are there late fees and or interest that are involved, and then any penalties for failure to pay the rent in a timely fashion.
And I think those are the highlights. The one other thing, because it's dollars and cents, so that's always important to me and important for me to look at for my clients, is what, in addition to that rental amount, what other obligations, what other costs are you going to be responsible for? Residential leases, I typically look who's responsible for paying the utilities. Some apartments are all in, meaning that the utilities are included in that rental amount. Some you pay separately. You're responsible to pay those. Is there any additional fees or anything like that that you're going to be responsible for if it's in a homeowners association or anything like that? So it's really important, again, to have those in writing and to understand exactly what they make up and what they comprise, so that you know how much it's going to cost you to rent this place and you know what the terms are of your rental of this place. To flip the coin a little bit and to talk about the commercial side, there's no landlord-tenant act that governs the leases like there is in the residential. So it's even more important to have it in writing so that you understand. And in my practice, in my experience, having reviewed many leases, typically residential, not a lot of room for negotiation. Commercial is usually the exact opposite, where there's a lot of room, depending on what type of landlord you're renting from, to go in there to look at those terms and to negotiate them, to tailor them to your specific situation. But tip, when you're looking at a lease, commercial as opposed to residential, what type of terms are you looking at? Are you looking at the same ones you're looking at for the residential?
I'm looking at those terms. I'm also looking to see as far as terms as to what happens if one of the parties defaults on the commercial lease, and if there's what's called a confession of judgment. And what that is, a confession of judgment, is where a party, and typically in a lot of cases, the landlord, the commercial landlord, can go to a court, a prothonotary's office, and automatically, just with a copy of the lease and some basic pleadings, obtain a judgment in their favor, either monetary or possession, generally not both. And that's something I look for when I'm representing either a commercial tenant or a commercial landlord, and there's a dispute that arises.
No, great point, because it's really a draconian measure. Big tool for the landlord, because you can expedite getting a judgment, whether it is for possession or for monetary damages, in weeks as opposed to months, if not a year or longer. So very big tool for the landlord against the tenant that has defaulted. So very important for the landlord, very important for the tenant to be paying attention to that specific section. Along those same lines, a lot of times what you'll see is guarantees, a requirement for a guarantee, because commercial leases are usually for a larger amount for a longer period of time. Landlords want additional individuals or parties to be guaranteeing those terms, meaning that if there is a default, there's another party that the landlord can go after and seek to recoup some of the money lost as a result of that default. But I think the moral of the story is, make sure it's in writing, whether it's residential or commercial. Make sure you understand the terms that you're agreeing to in that writing. Potentially, if you have questions, seek the advice of a lawyer or someone qualified to give that advice to help you make sure you get the right terms for your situation, be it a residential or commercial. Tip, anything to add?
No, I think we covered it, Jim.
Great. Thank you again for tuning in. I'm Jim Kovaleski. I've been joined by Tip McCabe, attorneys with the law offices of O'Donnell, Weiss, and Mattei.
Thank you.